Good day. My name is Yossi Witkowsky and I'm an Australian immigration lawyer. Today I'm going to be talking about partner visas. Did you know that 23,000 out of 77,300 places is being allocated towards partner visas? The Department of Home Affairs is thus giving a renewed and specific focus to partner visas for the next few months going into 2021. To apply for a partner visa, you must be in a genuine relationship with your spouse or de facto partner, who is either an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. The key issue in a partner visa case is generally whether the visa applicant meets the requirements that he or she is a spouse or de facto partner, or in the case of a prospective marriage, genuinely intends to live together as a spouse of the relevant Australian citizen, permanent resident, or eligible New Zealand citizen. So what is a de facto partner? To be a de facto partner, you must be in a de facto relationship. You and your partner are in a de facto relationship if all the following criteria applies to your relationship. 1. You are not married to each other. 2. You are committed to a shared life to the exclusion of all others. 3. Your relationship is genuine and continuing. 4. You live together or do not live separately and apart on a permanent basis. And 5. You are not related by family. Being in a de facto relationship is more than simply being in a romantic relationship. Generally, your de facto relationship must have existed at least 12 months immediately before you apply for the visa. Please note that time spent dating or in an online relationship might not apply. The 12-month period will not apply if you, 1. have registered your de facto relationship with an Australian authority such as a registry of births, deaths and marriages. 2. You can show compelling and compassionate circumstances exist to grant the provisional visa. 3. Your partner holds or held a humanitarian visa. 4. Your de facto relationship existed before your de facto partner's visa was granted. And 5. Your de facto partner told the Department of Home Affairs about the relationship before the visa was granted. The partner visa is generally assessed at 2 distinct stages of the application. First stage being the provisional visa and the second stage being the permanent visa. To be granted a provisional or temporary visa, which is generally the first step before you are granted a permanent visa, the applicant must be a spouse or in a de facto relationship. For the grant of a permanent visa, the applicant must continue to be a spouse or in a de facto relationship at the time the decision is made. That is, at the time the permanent visa application decision is made, which is usually a period of about 2 years after the application is made. So you generally get 2 types of partner visas. Those that you apply for while you're in Australia, that is onshore, and then you get those that you apply for while you are overseas, that is offshore partner visas. In this video, I will introduce some of the general character requirements for partner visas. Since there is a lot of information to cover, I will do a few follow-up videos dealing specifically with the character requirements covering, for example, domestic violence. We will be looking at the character requirements for both the applicant and the sponsor. So if you are interested, then please subscribe to our YouTube channel by hitting the bell icon to be notified as soon as we upload new videos. So let's talk about character requirements. In order to obtain a partner visa, you must be of good character. So what does it actually mean to be of good character? To be of good character, you'd have to pass a character test, and you'll not pass a character test if you have a substantial criminal record. You'll be regarded as having a substantial criminal record if you were sentenced to a term of imprisonment of 12 months or more. If a person has been sentenced to 2 or more terms of imprisonment to be served concurrently, whether this is in whole or in part, the whole of each term is to be counted in working out the total of the terms. So for example, if a person is sentenced to 2 terms of 3 months of imprisonment for 2 separate offences to be served concurrently. For the purpose of the character test, the total of these terms is 6 months, 3 months for each offence, even though it is served concurrently. You will also be regarded as having a substantial criminal record if you have been sentenced to periodic detention. A person's term of imprisonment is taken to be equal to the number of days the person is required under that sentence to spend in detention. So, what have we learned today? We learned that in order to obtain a partner visa, you'll have to be of good character, and you will not be of good character if you have a substantial criminal record. Meaning, if you were sentenced to a term of imprisonment for 12 months or longer, whether it is concurrent sentences or periodic detention. In our next video, we will focus more on character requirements for partner visas, and we'll also be looking at domestic violence and partner visas. Thank you for listening. Have a blessed and safe festive season, and we look forward to engaging with you more in 2021.